Call the meeting to order. It is 8:35. Ms. Mahon, would you call roll, please?
Mike Mendez.
Present.
Tom Butler is absent today. Helen Collier will be here. Rick Figueroa is absent today. Catherine Rowald is absent today. Robbie Shaw.
I'm here.
Deborah Yurko. Here.
We do not have a quorum at this point in time, so I will not entertain a motion for our other commissioners that are absent right now. So let's move on to our staff reports. Item H. Mr. Francis.
Mr. Chairman, Brian Francis, Executive Director with TDLR. As you may be aware, we're in the middle of a legislative session. I think they're scheduled for 140 days. Feels like 279. But there's only 10 days left in the session. TDLR is poised for one of its most successful legislative sessions. There's a lot of work. We've had record numbers in the number of cost estimates. I was just talking to Tony. We've had over 209 assignments for cost estimates compared to 135 last session. That's quite a bit of information. We've had a record number of hearings that we've attended. I do want to give out some praise and some thanks to our core legislative team. And as you guys know, TDLR's process is collaborative. So there's a group of folks that are working on the legislative process, but the agency is the one who helps develop the information and the successes that we talk about. But Eric Beverly and Colleen Trine and Michael Kelly, they are the GRO folks that have been going over, the government relations folks that have been working with us. Nick, Carla, Randy, Brad have been part of the weekly, we do two meetings a week to go over legislative matters, to kind of see where we are, what we owe, what we need to do. Jeff Kopus, the thousands and thousands of pages of information that you guys have received, that the agency receives in regard to the bill status, where they are, what hearings are coming up, the in the loop, under the dome. Jeff is the primary keeper of that information. He does a fantastic job. Tony Cuvion in the back there is our numbers guru, and I just have to say that we lost Tom Spradler last session, and he was here last session, not with us this time. And I've told Tony before that Tom would be extremely proud of the fantastic job that Tony has done. He's really, really carried that mantle well. Susan Stanford has also participated in those meetings for us for the legislative updates. We've had more people testify or be in the chair for us than we've had in the past. Lee Parham, George Ferry, Mark Black, Michael Kelly, thinking about more, Randy Nesbitt, a few more that have been out there, and it's been exciting to make sure that we're spreading that wealth and that experience. I want to go over the information that Rhonda's getting ready to pass out to you folks up there as she comes around. Mr. Chairman and members, the information that I'm going to present to you, it's going to be in two buckets. Forgot to mention Mary Winston, who has been in the seat over at several hearings for us and is also a major part of our team and our efforts in those meetings as well. So the first bucket I'll start with is the deregulation strategic initiatives. As you can imagine, this legislative session, they have been extremely popular. A number of members have been excited to work with TDLR in those initiatives. It's been exciting to hear them lay out the bills and say, members, back in 2016, the Texas Department of Licensing and Regulation undertook a strategic planning process, and these are the results of that process. Several of those bills are moving in two areas. You have the individual bill, for example, 2113, 1498, 1500, 1501. Those are individual bills that are moving forward with the deregulation of those areas, whether it's for-profit legal services, temporary common workers. And then you have 2065, which is an omnibus dereg bill. So all of our dereg elements and initiatives are included in that one bill. So the key there is you have multiple tracks. At this point in the game, you want everything that's a House bill to be on the Senate side and in calendars, pretty much, and you want everything that's a Senate bill to be on the House side and in calendars, and we have that. We're positioned for a big day today on local and uncontested calendar. Saturday is a big day. If Senate bills are not reported from committee, then those Senate bills will die on the House side. All of ours have been moving, so we're exactly where we need to be. Things can happen at a moment's notice, as you know, with the legislative session, but I'm excited about where we are on the deregulation strategic initiatives. A very big deal. You know, Commissioner Yurko, you've talked about that in the past of, man, we're getting big and we're getting so much responsibility. This is an opportunity to kind of push some of those programs that don't have a big consumer protection element to it off the plate, so we can clear the decks for those that are bigger and maybe have more of a health-related consumer protection element. It's going to free up some of our staff's time. When you think about our customer service division, they may not get but 1,000 phone calls for temporary common workers, which means they're getting a call maybe once every 2 weeks. That's tough to stay sharp on that type of question. Cosmetology, they're going to be sharp in those questions because they're giving them every hour. So we're taking off some of those sporadic, infrequent touches. That may be my cue to leave, but I think I got to go longer, Mr. Chairman. Speaking on that, on page 2, she say open the door so we can see. On page 2, the secondary initiatives. Again, in the strategic planning process, we looked at impediments for licensure, things that were keeping people out of business, things that were unnecessary, things that took away our efficiency, and how we moved paper and applications and complaints through the system. And on the secondary issues, some of the key ones that you'll see there is 2738 and 2739. We have this challenge in the cosmetology area with the community colleges. You have a student that's there as credit hours, and then they transfer to a private cosmetology school. Well, now that community college has to recreate as if it was clock hours. This is going to give us the ability to develop rules that will allow for a conversion between a credit hour scenario and a clock hour scenario. It's going to make it efficient, but it's also going to make it easier for those students. It's not going to make it complex for the community colleges. This was a big issue that came up in our strategic planning sessions all over Texas, but primarily when we're in the North Texas area. The regulation of 2739 is looking at the size of schools, and more specifically, it is looking at the ability of TDLR to have rules that will allow us to issue a specialty license to a specialty school. So you have a school that decides, I'm just going to do manicuring. And now they don't have to meet the 2,000 square feet, the number of chairs, the number of desks, the number of equipment that a large school has to meet. They can have it tailored exactly to the size of that school. That's going to allow us to have an increase. You may recall 2 sessions ago, we worked on a bill with Chairman Smith at the time. And in that bill, we went from 3,500 square feet to 2,800 square feet for cosmetology schools. We went from 2,500 square feet down to 2,000 and 1,000 respectively for the barber schools. The impact that we've calculated is that back then there were about 40 barber schools. Today we have 77. That change in square footage made a difference. It allowed more schools to come up. It allowed for people to have greater coverage. This was that issue that was helping with the rural areas. Remember, we had a couple of the barber board members that had challenges having a school in the Alpine area and meeting those students' needs. With 77 more schools, that made a difference. I think this change is going to have a similar impact, and we're going to see a growth in specialty schools, and you'll just have manicuring schools, and that's going to make a difference for folks. It's going to allow them to get in, get out quicker. 3257, we call that the, and in fact, one of the members who laid out the bill said, members, this bill is going to provide liberty and freedom to your barista. And the other member said, sounds good to me. Right now, when you look at the definition of a boiler, the size of the espresso machines in different coffee shops have encroached into what is a boiler. This would pull them out of that. There have been no incidents, no consumer protection, no health and safety issues associated with a espresso machine blowing up. So we felt comfortable going there and not kicking in the doors of the different coffee shops around Texas. So it's an important bill for a lot of Texans out there. Senate Bill 848. If there have been some themes that have creeped up over this session, there's been a lot of interest in driver education programs. specifically the parent-taught program and who can teach it. I would say there are about 4 bills that were filed, if not 5, that said not just the parent, the guardian, and the grandparent can teach the parent-taught course, but in one area, I think Chairman Bonin had a bill that said there were disabled parents that wanted to assign the ability to teach that course to a friend or somebody they knew. You couldn't do that. Parents who had well, not parents, but you had parents that were incarcerated, couldn't teach their child to do it. So there were local law enforcement officers who said, I'll fill in that gap, working at the what is it, the YMCA? Yeah, I was going to sing the song just to get it in my head, but the YMCA.
Please do.
No, please don't, please don't, please don't. So we saw this number of bills kind of circulating around who can teach it, and now 848 and House Bill 912 includes a provision that says, by the way, a parent can assign somebody who's 25 years or older and who has driven for 7 years to teach that course. And so it's expanding the number of folks who can do it, but it's going to allow for those parents that are in some difficult situations to be able to have their child have that option available to them instead of having to go to a commercial school. The bottom line is that we're going to be able to handle it. We're excited about it because we were telling a lot of folks no who really had a tangential relationship with that child, and now we're going to be able to tell more people yes. And it's still going to be connected to the parent requesting that. So that's a big deal for a lot of folks out there. Mr. Chairman, I'll just touch on some of the TDLR-related programs.
I have a question.
Yes, ma'am.
Before you get off that, do we have a plan to get that word out to parents? Because I think that would be very important to the public, but I'm not so sure that would be something that would be noticed amidst all the stuff that's coming out of the legislature this session.
We'll definitely do it as part of, as we get our bill implementation plan together. We always build in an outreach component, and it's specific to the different programs. So for this one here, we'll make sure that we reach out to the charter schools, to the high schools, and to the different groups.
Okay.
We usually go through the list of witnesses to see who has testified on it to make sure that we are touching those groups so they can be a distribution point for us. We'll definitely do that then. Mr. Chairman, I missed an important one. On page 2, House Bill 4007, I think the bulk of what we've done this last legislative session or strategic planning process was to take a look at those 13 health programs, look at their statutes very closely and say, man, this doesn't fit TLR's business model. These have business impediments, whether it was the hearing instrument fitter program that required an individual to hold that license if they were the CEO of a corporation, all the members who are in a partnership to have to hold that individual license, all those cleanup elements that we identified, they're in House Bill 4007. That's a very comprehensive bill. It's going to require a lot of work on our part, but at the end of the day, it's going to streamline those processes and match those programs with TDLR. It looks like it's something very little, but with those 13 programs, there was a whole lot of effort that went into it. Yesterday was a really big day for that hearing. That bill was heard in Senate Business and Commerce. That's a big deal. We're hearing that's getting ready to get reported out. But again, with the House bill on the Senate side, it really means that it's got some legs, and so we're crossing our fingers on that one. That's one we're going to watch very, very closely. As the
Say
session
Saturday's the deadline for reports to come out?
Saturday is the deadline on the House side.
Okay.
For Senate bills. The Senate, because of the way they're structured, they can suspend rules on everything. The House is a little bit more rigid with their 150 members. They've got a process, and those deadlines are rigid and they are firm. But the Senate can suspend the rules with 2/3 votes or majority vote, depending on what the motion is. So they're not as tight on that end, so we feel very good about the House bills are on the Senate side. And we're hearing nothing but favorable things as well. House Bill 3029, that one's getting some legs and it's moving. We had that hearing yesterday in Senate Business and Commerce. It's an air conditioning bill that would create the 3 tiers. So right now, you have a registered technician and you have a certified technician. Well, the certified technician in TLR's world today is somebody that says, hey, I went to this course and I now have a certification. Call me a certified technician. You have about 5,000 of those folks. This bill would say the registered technician is somebody who can just get in, send their name in, get the criminal background check, pay us the fee, of course, This is going to create a certified category where the certification program has to be accepted or approved by TDLR. There'll be an examination tied to becoming certified, and then you'll have the contractor level. If you haven't figured it out, it's going to look very much like an apprentice, journeyman, and a master. And you're going to see that on the AC side, and they have not had that before. So that one's getting some legs. It's been very, very positively received. The costs are going to be de minimis. I think we have, TC, how many employees do we have for that one? Is it ACR 3029, is it 2 or 3? 1.5, okay, 1.5. I was thinking 1.5. He's going to check. I love him. So that's a new one. It kind of came out of nowhere. Barber and cosmetology, extremely popular. Some of the popularity was created through our strategic planning process with the deregs, whether it was on the shampoo apprentice, whether it was the dereg on the threading side of the equation. But there was also a lot of school stuff that was being looked at as well. There are 2 more bills that are carrying some movement with it. The 2 on there, House Bill 2304 is another look at the clock to credit hour scenario. It also has a provision that says that TDLR will develop rules that allow for a closer look at the sanitation provisions. Mr. Chairman, you may recall when the programs first came to TDLR that we worked closely with the Disease Control Center for the Department of State Health Services to say what's the extent of the health-related issues for our rules. We'll probably go through that process again to take a closer look to make sure that if there are any changes in the sanitation protocols, that we get those incorporated into to that process for those licensees. Mr. Chairman, on page 4, that's that series of bills I was telling you about with the driver's education that had it was changing the requirements for the parent taught who can be an instructor. The other theme that kind of brought itself up into this session for driver's education was the interaction between a police officer and a driver. We've seen the news on those scenarios out there. So there are a couple of bills that would require TDLR to work with some of the law enforcement groups and other stakeholders to develop a curriculum, just a piece of a curriculum that would allow, that would teach the driver on how they need to interact when they're pulled over at a police stop. And that one's taken a lot of legs. I think we have till September 1 to get that curriculum up and running. Senate Bill 30 will probably be the vehicle through which that will happen. I know I said vehicle with driver's training program. It happens sometimes. Senate Bill 1051. Mr. Chairman, you may recall the lawsuit involving TEA, Marath, and that dealt with having an option, an educational option for hard of hearing and deaf students in the driver education area. This bill would require and allow TDLR to create and develop curriculum for hard of hearing. We have the ability to contract with, we have the ability to collaborate with different groups to develop that. We've got about till June of next year. We're looking forward to having a lot of interesting conversations about it. The testimony was fantastic and fascinating. One of the ladies just said, you don't have a video that has someone signing the whole thing. And I don't want to see that either. Make it entertaining and engaging. So we're already kind of getting the feelers out there to figure out which groups we can work with and create something exciting. And Commissioner Yurko, we're going to have something a little bit more exciting than the video that we showed earlier so that these kids will stay engaged in the process for driver's education. Nick's over here smiling.
He has some excellent ideas, by the way.
Outstanding, outstanding. On that same page, page 4.
No, I'm sorry.
It was
Wrong
Ken.
credit, Ken.
Collaborative.
Ken has some excellent ideas as well.
Yeah, look at it. Look at it. Okay, on page 4, electricians, House Bill 1284 and 1698. Both of those bills are moving. One would, well, they both have a similar angle to it. There are electricians that are currently doing work today, but in the lineman journeyman case, they're being tested under the National Electrical Code for wiring a house and wiring commercial buildings. But there is another, the National Electrical Safety Code, which is targeted to the work they do for the line and the power distributions. So 1284 would simply align their examination to the work they're doing. 1698 has a similar provision to it. The folks that are industrial journeyman electricians, today they can do that work as an apprentice, and most do. They can also do it as exempt work, depending on if they're employees of that industrial petrochemical plant, or they can do it as contractors if they've had a contract that extends beyond 12 months. This is going to allow for those folks who are apprentices to, if they want to, they can apply for this journeyman industrial electrician path. That examination is going to be based off the work that is specific to that work in a petrochemical plant and industrial facility. So both of them have that similar frame of saying we're going to align the examinations to the work that these folks are doing. And we'll continue to watch that and see how that bill progresses. It's on a path to move forward, but we'll continue to watch it and see what goes down with that. Senate Bill 1107, I'll just be very brief on that. You know, there's a lot of discussions on the, on telemedicine, particularly with the medical board. We're in that world now. We have healthcare professionals that are trying to extend the reach of their services, and get to those rural areas, get to the small schools. When you look at the speech language pathologist or the dyslexia therapist, those folks are trying to figure out how do you have that person and that expertise in that small school district. Telemedicine is going to be one of the solutions. And so you'll probably see some rules coming out of the advisory boards that allows for maybe more use of telemedicine. This bill does not specifically include our programs, but it hints to it enough that we're going to need to be mindful and factor that into the things that we're doing going forward. Massage therapist, I'll just touch on two things there. A part of the push has been how do you get more information in those facilities about human trafficking. So there may be some notice requirements. There are definitely some other civil liability scenarios that are cropping up inside of the statutory changes. Doesn't technically hit us, but it speaks to the new program that we're going to be regulating. The other big piece that's in 4007 is that it creates, we're not going to know that it's going to make the full race, but it would create a massage therapy advisory board. We think that's critical for that group to have a voice and an opportunity for us to come together and talk about the issues.
That's currently not in legislation.
It's not in legislation. It has to happen through 4007, so we're crossing our fingers big time on that.
There's been a discussion about having a poster of some type. I think we talked about this, of having a poster
Yes, sir.
at each one. Now, can that be done by rule?
It cannot.
Okay, so it has to be statutory.
It would have to be a statutory change. There were two bills that were introduced. One would require notice and signage and even continuing education hours relating to domestic abuse and also relating to human trafficking. Those bills, at least on the House side in those versions, didn't finish the race a couple of weeks ago. But as you know, in the session, there are things that can happen, and so we're keeping an eye on the different vehicles and avenues that those things could be attached to. And we'll let you know how that turns out. Mr. Chairman, on page 5, Commissioners, 2886 and 1081, right now the midwife and other healthcare professionals like physicians are required to administer the drops in the eyes of the infants. And as we know in Texas, the parent can choose to not have those drops done for their child. The statute as it exists today says you must do that, and if you don't, it's a criminal penalty. These two provisions, or these two amendments here, would simply say you must do it, but if the parent says no, you're not going to do it, then there's no criminal penalty attaches to that midwife as long as they document that parent's choice in that scenario. This was definitely the session of towing and booting. I think at one point, and I don't want to exaggerate, but I think at one point we're sitting at 31 bills dealing with towing and booting. That's a lot. 31 bills is a whole session for, actually that's about 4 sessions for a regular agency. And to have 31 bills on that issue, they came up for various reasons. Whether it was an incident that happened in a district where some people were saying that booters were putting on multiple boots on vehicles and charging people for that. We had not had any complaints of that nature. There was some talking about the issue of spotters, people standing in the parking lot and saying you must get towed. It was just all over the place. We contributed to it because we had a number of strategic initiatives that we thought would make the regulation of the towing and booting program more streamlined, more common sense. As you may recall, we recommended that the dual license go away and that we just simply expand the scope of a tow operator to also work in the VSF. Before, they had to have the two. We just simply expanded their scope, doing away with the training towing license, which no one used in the last 4 years, things of that nature. Having some common sense to the signage. You know that over time there may be shrinkage that takes place when signs are outdoors, and giving our staff the ability to have tolerances, that if it's 1 inch and it shrinks down by 1/4 of an inch, that it's still legible, that people can still have the proper notice. So there's a lot of stuff going on towing, but at the end of the day, there's about 3 or 4 bills that are still making it through. I'm happy to say that those bills are the strategic initiatives that we worked on. There's a couple of bills that would address an issue that we've run into a couple of times where you're at an apartment complex and the apartment complex is getting ready to do maintenance and they're going to restripe the parking lot. Well, then they send a notice to the tenants, hey, move your car in 72 hours, we're going to stripe this area. The tenant doesn't move their vehicle. The only way they can move that vehicle is it's towed to a VSF. There's a provision in 2976 that allow the commission to develop rules that say, no, that vehicle can be relocated to another location on that parking lot based on whatever our standards are. And that just makes sense that a person doesn't have to go to a VSF to get their vehicle and all that stuff. So we think those type of common sense provisions are going to be something that's worthwhile. There's also a provision in 3306 that...
Real quickly on that, is there going to be a charge to the car owner if it's relocated?
I would imagine so.
I would too, but I just don't know if there's provision in there.
There's a cost, but the key is that's going to be based on commission rule. So it's going to come back before this body decide what are the things that need to be included in there.
I do want to point out to you, we talked about this a long, long time ago, but there are certain states and districts like the District of Columbia, if you need to be towed, they don't necessarily go to a VSF. They will put them off-site and still notify you, and you still have a ticket. Just like, you would buy a parking ticket, you still have to pay for it.
Mm-hmm.
So I don't know if this is going in that vein, but it's something to consider, because I thought it was pretty efficient, having been towed myself in DC, to know that I didn't have to travel to the outskirts of the county and find a
Absolutely.
ride there.
And it is going that direction. In House Bill 3306, there's some language that's been added that will address that exact situation when you're on a university campus.
Mm-hmm.
And let's say that there's a big game, OU's going to come down there and beat somebody. If they would ever allow us to
In
come
Austin,
here.
is that what you're saying?
Yeah.
Wow.
Yeah.
Wow,
But
that
it's
went
not important.
off the rails real quick.
It went quickly. It went quickly. I'm not worse. I'm not a worse known enemy. So the language would simply say that if there is a special event that's taking place on a university campus, whether it's a private university or a public university, that university must provide, I think, 72-hour notice. 72 hours, 72-hour notice to the people saying, hey, these cars are going to need to be moved, or else they're going to be relocated to another area on the campus. What you may see in that scenario is there may be a ticket saying, oh, your car's been moved and it's over here. And it's exactly as described, and it lessens the ability of a student or a visitor to that campus having to go off-site to a VSF, pay the storage facility, have someone take them out there. They'll know where it's at. And so that's in 3306 and I think 1501, but don't quote me on that one.
Because I noticed also in Austin, for example, after a certain hour, 6th Street, you have to have your cars off, and the police are constantly going down with the loudspeaker warning people, and it would just be so efficient if it was, they still have to pay the expense of it, but it'd be a little bit more accessible than having people to figure out how to get there.
Where to go? We may get there.
Yeah, I
We may
have a
get there.
question also
Yes,
with
ma'am.
what you said earlier, something about consolidating. Have we ever thought about, like, for example, this issue's been brought up to me by other electricians in the past.
Sure.
If you have different licenses, is there a way to consolidate them so they're renewals the same time rather than having to keep doing the application process every 6 months or 3 months if your licenses are staggered?
We can take a look at that.
Yeah. It seems like it would be an efficient way to have that.
Sure.
You know, whether it's prorated the first year, so you get them in sync, and then it continues, you know, together, so at least you can handle them all at the same time if you chose.
And most of our statutes, not all, but most of our statutes have the ability for us to prorate fees and to stagger their issuance, so.
Right,
we
but
can
it'd be
look-
nice to be able to do it in reverse if they want to handle it at one shot.
Absolutely. And you're gonna see that primarily with the ACR and the electrician licenses. They got them at a different time, the program started differently, and so that's what's
Exactly.
really, we're talking about, okay?
And it's been different electricians when they've known what commission I sit on, they'll say, have y'all ever considered that? Because it's pretty inconvenient. I'll update one, and then 6 months later I get another
Get the other
update,
one.
and I'm like, oh, why couldn't I have just done it at one time?
Take a look at that. We'll have our genius Willie check run a report to see how many people hold the dual and
Willie Beam.
what that looks like. Water well driller. So we'll get to page 7, new and transfer programs. There's several possibilities, as you may be aware. House Bill 100 has passed the House and the Senate and is sent to the governor's office yesterday. That bill deals with transportation network companies, which are ride-sharing companies. We will, if the governor signs the bill, if it goes into law, we will be responsible for the regulation of the companies. We do not delve down into the drivers. So we'll be working very vigorously and very quickly to put in a place for the regulation of those entities. The complaint process is going to go through the companies. It doesn't go to TDLR in terms of if there's a bad experience with the driver. The statute specifically provides for a mechanism for those entities and companies to resolve the complaint, to take action about suspending and even removing a driver if it rises to that level. There's that's singular. There's several interesting pieces of the bill that we'll be working on. One is developing a pilot program. Each transportation network company will be required to conduct for a 2-year period a program that evaluates its accessibility for persons that are disabled, that are trying to access the vehicles. They will be required to choose one of their 4 largest jurisdictions that they drive in to do that test on. TDLR, by rule, the Commission's work will enumerate and establish the standards of the elements that will be included in that report, the mechanism by which the report will be delivered to us, and then ultimately to the transportation committees in both the House and the Senate. That report will identify things such as the number of drivers that wanted to have, that needed disabled services or accessibility services for their driving, how that entity handled it. Did they refer the call? Was there a delay in that vehicle arriving to that location? Was that delay greater than the delay for a vehicle arriving to pick you up, Mr. Chairman, that comparative analysis of the quality of the services? So that's a new piece. There are several timing elements. It's 90 days after the entity gets its license, or no later than January 1, 2018, that they have to begin the process. It's 75 days after it's 100 days after they start the process that they have to report to us a general status of it. And it's 75 days after the 2-year period ended that they have to give the report to the transportation company. But we will be the ones developing that process, the form, the mechanism by how that information is gathered. So that's going to be a lot of work that we're going to be really working hard on very quickly.
And was this was upon signature, the governor will be effective immediately?
That's correct. It's a very unique immediate effectiveness. Typically, immediate effectiveness means we have to do something in order for it to get started. The immediate effectiveness in this bill says that if you are a transportation network company operating on X date, and I believe the current language still says on the effective date of the law, and if you are operating in any city in Texas on that date, you now can operate in every city in Texas.
So-
And those, the provisions in those cities are now void.
And without having the rules in place, I guess we're gonna be tackling that right off the bat. That's gonna be put in kind of high gear in order to get the rules
Absolutely.
established.
We've already sent word out to comprise our bill implementation team. We typically have a little bit more time to put it together.
Not this
We're
one.
working on the timeline for when rules will be effective. We're going to build in the TDLR way. We're going to have stakeholder meetings where we bring folks in to know who we are, but also to recognize that you have the regulatory, the regulated industry. You have the drivers. People have come to really rely on that service. You'll have the cities that are going to want to know what you're going to do and how you're going to take care of my citizens. And we have the disabled community that we're going to be responsible for. And we want to make sure everybody has a voice at that table as we move forward and bring the commission rules. We're also planning a public rule forum in the middle of the public comment period so that we just have that touch.
So what's the timeline to have rules in place?
We have not finalized it, Mr. Chairman. I'm working on that. I met with Brad's staff yesterday. I've got a couple of dates, but if you'll allow me to tweak that before we announce that. We're going to get with
You
our...
better get the tweaking quick, because it's, like I said, upon signature, it's law.
But it's not us.
Right, no, I understand that.
Yeah.
But
They can do
they can
everything
work.
they want to do
And this
without-
just regulates the companies and not the drivers.
Absolutely, absolutely. So we're going to definitely be responsive. We're going to knock it out the TLR way. But we're going to be smart and deliberate as we move forward with it. I think the process is so valuable to make sure we get that right.
Sure.
House Bill 162 is a bill that just got a hearing yesterday, and I think it was voted out of committee as well. House Bill 162 is basically saying that TDLR can approve an online course for a person that a judge has said needs to, basically has had animal cruelty concern. And this says that treat your pets better bill. And so it's an online course. Currently, the judge can point somebody to a shelter, a humane society, to get that training. This would just allow for an online version of that training as well. So it's something that we'll be developing over time, and it's a very niche part of it, but we've worked with Ray and talked to him, and we'll be able to meet the challenges of that opportunity if it comes our way. House Bill 3078, that's the sunset transfer of the podiatry board to TDLR. Remember, that's a September 1 effective date, so we'll be moving very quickly to do several things on that. One is to make sure that the bill implementation team is in place, to get Jody's folks lined up. They're already thinking about how we'll get it up day one and how we'll modify it over the time that it gets here, but also to think about those employees that are tied to that program. It was a standalone agency with 4 FTEs. So the language in the transition, or the transition language in the bill, provides for TDLR posting positions and giving the opportunity for those folks to apply back for their jobs. And as you know, our track record with the cosmetology program, there were 43 FTEs associated with it. We hired 38 of them. There are 14 associated with the barber program. We initially brought on 13 of those employees. We've had similar opportunities with the Department of State Health Services programs. There's been value in bringing people who have had experience with those programs, and we're going to look towards that as well. Senate Bill 589, Mr. Chairman, be the last one that I'll touch on for possible new and transferred programs. Senate Bill 589 is for behavioral analysts. I think there's about 1,100 in the state. These are the folks that provide direct services to individuals who have autism. I will just tell you that the testimony on the House and Senate side was it was beautiful, it was emotional, it was tough. Watching some young kids who had experienced autism at such a young age and the transformation in their abilities as a result of behavioral analysts. It was a beautiful thing to see. So that program is getting some wind. It would be a brand new program. It obviously does not encroach on the scope of practice for other groups. It doesn't encroach on psychologists, even though there were some concerns raised at the hearings that it would, but it did not. It did not encroach on speech-language pathologists. It is this niche group. I'll be frank with you that it's a straightforward program. It is a program that says if there's a national certifying group and they have passed that certifying group's examination, then TDLR shall issue them the license. So it's not a lot of discretion on our end for that. So we'll be ready for it if it comes to us. We'll be ready for it. Mr. Chairman, those are the only bills I'd like to highlight. Obviously, there are other agency bills that Brad's group's going to have to work on, whether it's dealing with the open meetings and open records. Sharon's group is already evaluating any of the HR personnel-related bills that are out there. Jody, Kent, they are focusing on the cybersecurity bills that are out there, and there are a number that are dealing with that. And then finally, Jerry and his craft are putting a close eye on the contract provisions, and there are, as we would say from the Three Amigos, there are a plethora of those bills that we'll have to keep an eye on and maybe modify some of our processes as we go forward.
Say, I'm sorry.
I had a question.
Yes, sir.
Brian, that was a very succinct and detailed report. I appreciate that.
Thank you.
It's good. Couple of questions. First one, based on the bills that are coming through, has TDLR staff looked at the staffing needs and the increase in staffing based on what our current population is to where we should be at if some of these bills came through?
Commissioner Shaw, we have. That analysis is done concurrent with the bill as it's moving through. And in fact, you may see a bill that starts off when it's introduced, and as we run it through our cost estimate team, Tony leads those up. They're doing the analysis of the licensed population. They're looking at the elements of the bill. What work do we have to do? Oh, does it require fingerprints? Does it require X and Y? And we will go through the analysis, and we may say on the file version that it's 4 FTEs. Dee Dee's going to get one's going to go to customer service. Christina, who's very aggressive in these processes, oh, you need to give me 15 prosecutors, whatever it is. We factor all that in, and she said 2,000. And we factor all that into the analysis, and we may say we need 4 employees for it. LBB maybe agrees with it and says, okay, in the final fiscal note, 4 employees. When that bill is heard, and if there are amendments added onto it, we go back and we do another analysis of it. And we have seen our cost estimates change by saying we need more now that you added X, or we needed less now that you added Y. We look at the different programs, and as you kind of heard me allude to with the behavioral analyst, if it is a program that has a simple licensing component, then Dee Dee's not going to need as many folks in licensing. If it's a program that requires, has a very high population, then we're going to do an analysis that says we can anticipate X thousand phone calls over the course of it. Definitely on the front end, we're going to need a customer service rep. This is a unique area that we need to have some expertise in. We're going to need a general counsel in that area. And so we are always looking at the mix. Just last week, we took a look at all of our programs that had some possible FTE increases and just put it on the board and said, oh my gosh, okay, that's a gap. And so we're constantly tweaking that and giving that information. Tony has developed great relationships with the Legislative Budget Board staff. They respect the work that we do, and so we've been able to prevail upon them in moments and say, we missed that number here. We really need a licensed specialist versus a person in administrative assistant. So,
My second question was, I really believe that TDLR has become a catch-all agency for the state when it comes to licensing and regulations. My concern is that with all the bills that are coming through, do you anticipate us losing our core function with, or dilute our services to the stakeholders that we're serving, because we're growing leaps and bounds. We're picking up everything from cosmetology to, now autism and everything else that's in between. Don't you feel like at some point that TDLR staff and the agency will have to relook at their business plan, look at something that we're doing that may have to be bifurcated out? I'm just kind of putting this thought process in
Sure.
your mind that I think we need to start looking at how do we look at our organization. Is this something that needs to be revisited again?
that's an excellent question, and I would answer it simply like this. We've been looking at that for the last 5 years. We've been anticipating these movements incrementally, strategically for the last years. The training that we've done internally to get our staff positioned for thinking functionally or thinking about specific issues. For example, we have staffed up and beefed up our health-related experience and knowledge. from gathering those folks in the Department of State Health Services. That's new. We didn't have those folks a year and a half ago. We've got them on board now. We're rolling them to it. I will tell you that when you look at the programs that are coming on board, behavioral analyst is going to flow right into our health group. Podiatry is going to flow right into it. That new core of activities that we're doing. But we've already anticipated that. We felt that was coming, and we're building towards that. The transportation network companies, in terms of the licensing side of it, it's streamlined. We will have between 13 and 20 companies. That's it. There's not a lot of discriminating factors that we have to evaluate in approving a company or not. Had the drivers been in there, then the complexity would have ramped up quite a bit. Had the statute required us to reach down to the drivers through the company, then the complexity would have creeped up a little bit. There are 41, now 42 states that have a very similar model of regulation of the transportation network companies. We're not going to have to reinvent the wheel, except for that pilot piece on the reporting.
So you've got the pulse.
Absolutely,
Put your
and
finger on the
I'll promise you, we have been looking at these changes in our agency for the last 5 years and anticipating that and making the incremental changes and adjustments in how we're structured. And we are positioned, and another big piece of that analysis was being shed of some of these other programs, not having vehicle protection product warranters, temporary common workers, legal service contracts, the booting provisions. Those deregulations are going to help clean up the plate a little bit, so our intellectual capacity is not, kind of focused on these things that are outliers. So allow us to focus more on the big picture issues.
And my last question is one that I think I've been talking about for quite some time, and that is, with all these bills coming through, you have to look at your facilities at some point.
Yes, sir.
With the expansion of the number of FTEs that you'll add, the different programs, accessibility to our stakeholders. I really urge you to start keeping that on the radar and
Yes, sir.
looking around the corner, because that's very important to look at a facility that will cater for all these programs, for whether it's walk-in customers, whether it's, our staff, parking, and everything else that goes in between there. So I really urge you to keep looking at that as well.
And Commissioner Shaw, we're aggressive in that area. We are blessed and fortunate to have Sharon and the talents of Bob Posey on our staff to help with the facilities planning. There's a couple of things that are going to impact us in the area. Facilities planning and changes are also going to happen to us versus us being able to drive it. There are 2 projects, 2 phases for construction in the capital area complex that we know at some point TDLR and its folks are going to be pulled back over into that area. That's just going to happen. And there's not like, oh, Brian's going to throw a tantrum and it can't happen. It's going to happen. The state as a whole is looking at its cost in leases and saying, can we still afford to have these 25, 95, 2,000 agencies out in privately leased areas, or do we create a localized more state offices? And they're going down that path. When we look at these programs here, a year and a half ago, we were already having, and thanks for coming in, Bob. A year and a half ago, we were already having conversations about if we grow by X in this division, where are those folks going to be housed? So we know what our capacity is now, and it's freaking Bob and Sharon out, but they're handling it. They're doing a great job. But we know what our capacity is to take on new programs. It's just that way out of the blue program that would, we're going to give you 95 people. I would lose some hair then, what little I have left.
Just a quick reminder on that.
Yes, sir. I thought you were going to ask me the question about interdisciplinary boards, of having one board for AC and electricians.
That's going to come next.
Well, I wanted to
Next
let you know that in our discussions this legislative session, we went through that scenario a couple times about interdisciplinary boards with the Behavioral Health Council, Executive Council, that we were working with the Legislative Budget Board on, and the Sunset Commission on. There was a lot of discussion about that, and we saw the value of it, the benefit of it. We saw some of the downside of it, but I think it's a conversation that's going to probably take place in earnest over the next probably next 4 years.
Thanks, Brian.
Yes, sir.
Say George is up to bat.
Yes, sir, George Ferry.
Come on up, George.
Good morning, Mr. Chairman, Commissioners. I am George Ferry, your Director of Compliance here at TDLR. I'm going to give you, provide some highlights of my written report, but as reviewing my report, I realized that all but two of the items on my report are in an area that's primary to the compliance services, and that is outreach. We do a lot of that, and we've been doing a lot of it. So I want to highlight a few of those items for you all this morning. So one just occurred yesterday. David Gonzalez, one of my regulatory programs section managers, and two individuals from the health professions, two program specialists from the health professions section, Yvonne Feinleib and Katie Bryce, and myself, went down to San Marcos to the Texas Environmental Health Association conference. They're primarily composed of code enforcement officers and sanitarians, two groups that will be taking over come November 1 from DSHS. We got a chance to talk to them about the transition and the dates when all this would happen. We'll also be talking to code enforcement officers at the Building Professional Institute in Arlington, which is next week actually, along with our usual stuff there at BPI, architectural barriers, electricians, that stuff. And we're also on tap for the Building Officials Association of Texas conference here in Austin in August, and that'll primarily be about code enforcement officers. But some of the other programs too, two of our staff in the Industrialized Housing and Building program, Brian Ledbetter and Catherine Vaughn, participated in a training event up in Waco back in April. Had about 60 folks there with questions about the IHB program. Our Chief Elevator Inspector, Jim Mernan, and Deputy Chief Jared Bledsoe provided some training for elevator inspectors, again back in April, and that was up in Dallas-Fort Worth area. Our health profession staff have provided training, actually outreach to students related to the speech pathology and language program. These are students who will be getting into that program. We went there to talk to them about the process they have to go through to ultimately earn their license. And one other item I want to mention, our TOW and VSF program specialists in the compliance division, Todd Forrester and Latasha Poland, provided one of a number of VSF workshops that they have provided. This one was in Bedford back in April also, and they had about 33 people attend that. So those are the ones I wanted to highlight. There's others on there if y'all have any questions.
I think we're good.
Okay, thank you.
Thanks. I think, is Mary up for a advisory board report? You can speak from there if you'd like.
Oh,
You don't
that's
have to come up
perfect.
here.
Good morning, Chairman, Commissioners. This is actually my first opportunity to give this report. The Advisory Board Support Team offers support for the numerous advisory boards that we have. And before I begin the report, I sent an IM to ask how many meetings do we have scheduled for the summer. So currently we have 18 meetings scheduled for June, July, and August. And I want to say I appreciate all the commissioners who have come and participated and just lent an ear to all of the boards. For this meeting, we have had three, and I'm just going to go backwards. Yesterday, we had the Dietitians Advisory Board, and this was their first meeting since, I believe, September. And we had a new member on, and public comments, staff reports, and we did actually have the Enforcement Division present the work from the work group for penalty matrix, and they did vote to recommend that to the commission to move forward on. It's a very small enforcement piece. I don't know that there's one case maybe And they're looking, yeah, they're nodding. There's been like one case, so dietitians is not enforcement heavy, which is wonderful. But they did discuss why they did the matrix this way and so forth and so on. And it's just required for all of our programs. Architectural Barriers Advisory Committee met earlier this month. The highlight in that meeting was our IT specialist, Teresa Alvarez, gave a presentation on the new system for our architectural barriers. We have an outdated system, and they've been writing programs, and she did a PowerPoint, told them how it would work, gave them timelines, and they all seemed very excited about it. Lastly, Dyslexia Therapists and Practitioners Advisory Board. At this meeting, good morning, Commissioner Collier.
Hi.
Commissioner Collier and Deputy Executive Director Carla James welcomed that meeting and opened that meeting. And this is a brand new board, and the Office of General Counsel provided to the members training on open records and open meetings. And they also established work groups. Work groups have not had a chance to report yet, of course, but for enforcement, which will be penalty matrix, criminal conviction guidelines, and so forth, licensing work groups, as well as education and examination work groups were developed. And we all see that we have future meetings set, and I'm going to stop talking now because we have a quorum and we can move forward.
Thank you. Would make note that Commissioner Collier has joined us. I can now state that we do have a quorum present. So that being the case, let's move on to our motions for rehearing. Let's move on to item G1, which is Sparenity Nails and Herbal. Who's doing that? Yeah, go ahead and have a seat up here. Are you, sir? Go ahead.
Thank you. Good morning, Chairman, Commissioners. The first matter before you results from a default order in which the Department assessed administrative penalties against the respondent totaling $1,250 based on the respondent's failure to maintain proper cleaning and disinfecting records for the facility's whirlpool foot spas and failure to maintain cleaned and disinfected wax pots. Now, as you know, and I will consistently remind you, the Administrative Procedure Act requires a motion for rehearing to identify with particularity any errors of fact or law made by the department, and the motion must also state the legal and factual basis for any alleged error. The motion for rehearing process is the opportunity for the respondent to bring any error that the department has committed to our attention so that we can remedy it, not an opportunity to litigate the case in case of a default, or just to relitigate any, just begin the litigation process again. In this case, the motion for rehearing simply stated that the respondent wished to contest the department's findings and requested a hearing, and cited two of the findings from the NOAV. There was no further claim of legal or factual error, and there were no claims that notice was not proper in this case.
Mr. Chairman, Brad Bowman, General Counsel. Doug, would you just identify yourself for the...
Oh, thank you. Yes, Doug Jennings, Assistant General Counsel for the department. Thank you.
Appreciate it. Any questions for Doug? We have before us Brandon Lynn, is that correct? Lou. Okay, Lou, I'm sorry. If you don't mind, state your name for the record.
Brandon Lou.
The only thing that you can talk about in this particular time right now is where the department failed or erred in coming to the default decision. So, unless you've got something for us to do that with, we can't talk about the case. We can't talk about the facts of the case. We can only talk about where we erred in coming to our default decision in this particular case, because it wasn't a hearing, if I'm correct.
That's correct.
So,
We're new to this process.
right, I understand. That's why I'm trying to steer you through that. Just trust me, if you steer off of that, our general counsel will jump in, short of beating you with a stick, to tell you to stop, okay? So,
It's not a big deal.
so go right ahead.
Well, first of all, I would like to also, next to me is my wife, Maria Nguyen, and she's also owner of that salon. When the inspector came, I just want to have a brief discussions on the case, on what happened. He came and he looked at the few pedicure chairs that's way in the back. And
Sir, could you speak into the microphone a little bit? Just pull that a little bit closer if you would, please, so we can
when
pick
he came,
you up.
He went to the back and he saw some of the petty chairs in the back.
Test. If you like to use mine, you can.
There you go.
Can you hear me now?
Okay.
What he made note was some of the petty chair logs that's in the back that we haven't had enough clients to use. So we didn't really log those petty chairs. So he noticed that. And also, we have salon assistants which cleans the petty spot. We call into TDLR help desk, and they said that because we use liners and we have salon assistants, it's not necessary that we keep this petty log. So that's why we kept the petty log initially till I think the shop's opened like a year and a half. So we kept the petty log for roughly a year. And after we changed our process and how we did our businesses, we call into DLR to see what's the regulations for that. And it was brought to us that
Mr.
it's not
Chairman,
necessary.
I'm sorry to interrupt. This is Brad Bowman, General Counsel. I just wanted to, it sounds like we're getting into the facts of the underlying facts of the case, and as the chairman has pointed out, that's not the purpose of the hearing
have a
today,
question.
or the meeting today.
I have a
So-
question. Did you happen to receive the notice for the hearing originally?
That also was, the original notice came to us, but it was to the original location of the office. I had that rectified with my lawyer, and then my lawyer did change the new address location. But prior to that happening, prior to my lawyer doing his work, the notice came out and I never received it. So the notice that I received was months behind.
What is your address?
The current address of the 5695 Kyle Parkway.
Did you have 300 East FM
That-
2410?
That is our old address, that is
And
correct.
609 Maxon Drive?
That is our old address.
Okay, because we've got all three on file. And so it went to all three of them. So
We never received the one on 5695.
I'm just telling you that we've got 5695 Kyle Parkway, Suite 120 in our
Because I
files.
called into the TDR office, and they said they specifically sent it to the Moccasin one. The letter was sent to the Moccasin, and I think on their.
Did you let us know that you had changed your address?
During the time of the letter sent out, I don't know where the process is with my lawyer for changing that, so we were independent from that. But after I received the notice,
But the responsibility relies on you to ensure that the department knows what your new address is.
Okay,
And so, not knowing, we sent it to the address on file. And we're showing that it was delivered. Whether you got it or not, it was delivered.
okay.
So what are you hoping to get out of this?
I guess a mercy?
Okay, but you have a $1,250 fine.
That is correct.
So are you wanting,
Well, on there was like, if we pay early, it's reduced to a 900
are you wanting to
something.
pay early? Is that what you wanted to do?
That is correct.
So you're wanting us to, what was the, what was the
settlement amount?
Was there a settlement amount?
It looks like it was $925.
Is that what you're looking for, is a settlement amount?
And I guess, because I don't think that's here to discuss
Is that your,
that.
are you looking for the settlement amount? Is that what you're looking for, Brandon?
And
I'm sorry, I
also-
don't have a form for you, so I need you to either fill one out
Okay, great.
or let Brandon speak.
I guess, but I don't, anyway, it's, what she's saying is what I stated, is that the way that it was documented as our fault is not correct.
Okay.
But I don't know if we're to discuss that here.
Do we know the breakdown of the price for the foot spas and the wax spot, out of curiosity?
I will look at the NOAV just a moment.
If you'd like to speak, you can grab one of these and just fill it out. Yeah, and I can take it.
At least on the settlement, the initial offered settlement amount, I don't see it being broken down. I could be incorrect. but
And
gladly
is,
defer to enforcement.
if I may ask, is it required that they break down the breakage? No? So we are just given a total amount, and
The
that's-
violations and what the amount is going to be.
Well, the violations are based on the penalty matrix, and there are different categories of violations.
I
with
think
the-
that penalty matrix is located on our website, is that correct?
It is.
So you can go out to our website and find the penalty matrix for the violation that you had.
We saw that, it's very,
There's a
not
range.
clear. Yeah, it
There's
gives
a
you a
range.
range, we don't even know what exactly it amounts to.
But
Yeah.
for settlement purposes, we could consolidate you were asking if it's not broken down.
So are you?
We have, I'm sorry to interrupt, we've received some information. The settlement amount is based on a 75% of each violation's
Okay.
recommended penalty.
So give you some idea.
75% of what?
And we
Okay,
have a
right,
Class
okay.
D violation and a Class E violation. A Class D runs from, let's see, 300 to, it looks like $500, and a Class E runs, is about $750.
So we took 75% of each one of those.
Yes.
So 75% of 500, 75% of 750. Thank you, ma'am.
Well, yeah, I believe they
No, no,
reached
yes, I'm sorry,
925.
yeah, you're doing the same.
So wait, so
Thank you. I'm sorry, go right ahead, speak.
Yes, sir. On the paper, on the letter that state what we did wrong at the shop. Some of when the inspector when they write it down, and we should know what we did wrong, but he should write it down, and we never confirm. For example, the wax that we use, that we never use, it never on. So I don't think we're accused for that, responsible for that one.
Okay,
So
now,
few of the one that on the letter said that we at fault, but I don't believe that we at fault. And
Okay.
so we got five. I'm
well, and let me
okay.
tell you,
Yes,
the
sir.
problem that we have here is that failure to respond to the NOAV that you
Mhm.
received,
On the letter,
in the letter that you received, of course, you're saying that you never got it,
right.
but it was sent to you based on the address that we have on file.
Yes, sir.
And that's why, I'll tell you, but I tell everybody that's listening, it's very important that you change your address once you move somewhere, because we don't know that you've moved. So we're gonna send it to the address we have on file. It's gonna be the notice of violation, it's gonna tell you what happened and what went wrong. If we don't get it back, then we assume that it has been received. And now you're telling us it was a wrong address you never got back, but the process already gone through.
You have 3 address, so you send 1 out of those 3. You never send 3 out of those 3. So how do you know which one is which? Even me, I'm confused now because I have to go back to my
What
lawyer
was the
and say,
address that we
okay.
sent that NOAV to?
We sent the NOAV to 609 Moccasin Drive and 300 East FM 2410. That was the NOAV, and then the notice
For this?
order was sent to 3 addresses, the additional address plus the 2.
We got the last one, and
Okay,
that's,
but we sent it to the Moccasin and we sent it to the FM also for the NOAV, because that's the addresses that you had on file with us.
I have a question. When you were inspected, what location were you at?
the Kyle, the one in 5695.
Did
Kyle.
you notify us of that address change?
That is, there is 3 address. When I call into TDL, there's 3 address, and I have no way of getting the other 2 out. I call in, and then the person I spoke to on the phone says, change your business, because we operate under a Kuklu LLC. That has the 5695, now that should have the 5695. But we also have, we used to have a salon in Hawker Heights. So somehow, some way, the system is not letting go of the old address, and I'm stuck with the old address.
Is that correct?
I'll have to look at it, Mr. Chairman.
I think we may have some
I
information
think we
here
do
on
do
the
the
change of,
addresses.
when the change of address occurred.
Yeah, yes, we sent the NOAV to the addresses of record on file with the department, and that was changed subsequently, I think, February.
After the fact?
So yes, because the NOAV was sent in December, early December 2016.
So we sent you NOAV in December, and then you changed your address in February.
That's when we noticed that there was inconsistency there. But
Right.
prior to sending that, we have no idea, because when we call in, we don't know, even right now, if you call in, there's going to be 3 address.
And we'll
Yes.
send them to all 3.
For the last one, yes.
Yeah, we will.
Okay, I have a question.
Yes.
Hang on a second. I think.
In the original NOAV, right, what was the address of the violations?
609 Moccasin Drive, well, I'm sorry, that is the 5095 Kyle Parkway,
Okay.
Suite 120.
Did we send the notice letter to the Kyle Parkway address by any chance?
We did not.
And we,
Mr. Shaw.
I'm going in the same line of questioning as Commissioner Yurko. If we inspected a facility at 5695 Cal Parkway but did not send the notice to that address, whether we had the wrong address on file or not, I mean, it just doesn't make sense. So I'm inclined to saying, that I would be happy to make a motion to rehear this case.
Well, it's not a rehearing, it's a default order, so
Right.
it'll be remanded back to the executive
Correct.
director.
Correct.
That's what you're looking for. So we have a motion and a second to grant the motion for rehearing. All in favor signify by saying aye.
Aye.
Those opposed, no. Motion carries 3-1. So the staff will get with you. You got your motion for rehearing, okay?
Thank you very much.
You bet.
This is just a question for procedures in the future, because I know we tend to get this sometimes, where
Yeah.
with the addresses, and I know it's the licensee's responsibility. It's not a negative on the agency. But we may want to consider just sending a copy of the letter to the location of the violation, just to kind of cover our bases.
We'll definitely take a look at that. Obviously, the process is to send it to every address that's in the record that they told us where they want their
Which
mail.
totally makes sense, but if we're gonna send it to every address in the record, then we probably ought to include the one where the violation occurred, or the alleged violation occurred.
I'll get
Just a
with-
thought.
Okay, I'll get with enforcement and GC, and we'll talk about it. We'll definitely look into
Let's
it.
move on to item G2, which is Jose Perez. Are you present? Come on up here. Go ahead.
Okay, thank you. Again, Doug Jennings, Assistant General Counsel for the Department. This motion for rehearing results from a contested case hearing and subsequent ruling by this commission to deny the respondent's application for an apprentice electrician license. That decision was based on an administrative law judge's findings that the respondent's criminal history rendered him unfit for licensure. In this case, the motion for rehearing states, I was recently turned down for an electrician license. I am requesting an appeal, please. Once again, that does not rise to the standard set by the Administrative Procedure Act for a motion of rehearing, and the General Counsel, Office of General Counsel recommends denying this particular motion.
Any questions for Doug? Mr. Perez, if you don't mind, state your name for the record.
Yes, sir. My name is Jose Perez.
Mr. Perez, the only thing that this commission can consider, as you heard me say before, is where we erred in making our decision. We can't retry the case.
Right.
And as you've seen, if we start retrying the case, they're going to step in. So you need to tell us where we made a mistake in coming to our decision in the prior meeting. Go right ahead.
Well, there was really no mistakes, but I do have support letters that I did not have before.
Did you submit them in the SOA hearing?
I have them with me now.
Did you submit them in the SOA hearing?
Yes. I mean, no, I'm
Okay,
sorry.
they can't be considered now.
I'm-
They had to have come from the SOA hearing in order for us to consider them. So any
as
evidence
far
that you
as-
submitted,
Okay, I'm sorry, I'm not.
any evidence that you submitted in the SOA hearing
Uh-huh.
can be considered by us, but if you're bringing something outside of the record from the SOA hearing, we cannot consider it here.
Okay, now I'm kind of confused on this console hearing. What does that mean?
Was he present at the hearing?
I would believe so. Let me double check.
Did you have a hearing? Did you go
There-
to, was there an administrative law judge
Yes.
and you went to that?
Yes.
That's the SOA hearing.
Okay.
Yeah, State Office of Administrative Hearings, I'm sorry. We
Okay,
abbreviate.
well, yeah, because the letter that I received for me to do the rehearing, it is requesting support letters for me to.
And you should have taken it then, not now.
Okay, I see what
Yeah, I'm
Okay.
sorry. But we can't, if it's outside, if it wasn't presented at that hearing, we
Mhm.
cannot consider them.
Okay.
So,
Mr.
anything
Chairman,
else?
I'm ready to make a motion.
Anything else you want to say?
No, sir.
Okay, go ahead.
Make a motion to deny the motion for rehearing.
I second that.
We have a motion and a second to deny the motion for hearing. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Just so you know, you will have another bite at the apple. We denied your motion for a hearing, but there is also the ability for you to have, to take it into district court if you so choose, and staff can kind of help you out with that.
Okay.
All right, thank you. Appreciate it.
Yeah, have a good day.
Commissioners, let's move on to,
Mr. Chairman, may I suggest that we take up the next motion for hearing, item 3. We have a recommendation that the commission could consider granting that one, and we may run into a statutory deadline if it's not heard today. So that would be, if that's acceptable.
okay, let's go ahead and take up F3. I'm sorry, G3. Jake Davidson, Jake Stone.
Thank you, Chairman. Doug Jennings, Assistant General Counsel. In this case, The motion for rehearing, this resulted from a default order in which the department assessed administrative penalties against the respondent in the amount of $2,000 based on his alleged failure to complete required annual drug screenings. I've consulted with enforcement, and they have told me that the procedures that gave rise to this offense have changed, and they actually requested that the commission grant the motion in this case. It's my understanding that the circumstances that gave rise to this offense, the respondent would have the opportunity to correct this violation before it was referred to enforcement. So we also echo that recommendation.
So we had in our materials to deny, and now there's been things have changed since then that says it's a grant.
Yes, sir, and
Okay.
we issued a revised memo.
Yeah, it was a
Right, we have
revised,
it.
right.
So we have a recommendation from GC to grant the motion for hearing for Jake's Towing.
Right. And I
Yeah,
move,
motion.
Mr. Chairman, to...
We have a motion.
Correct. So move to grant the
Yeah,
recommendation over here.
we have a motion.
Oh,
Get a second?
Second, sorry.
All in favor signify by saying aye.
Aye.
Those opposed?
No.
Motion carries 3-1. Let's move on to item G4. I'm sorry, yes, G4, which is family towing.
Thank you again, Doug Jennings, Assistant General Counsel. This matter resulted from a default order in which the department assessed administrative penalties against the respondent in a total of $5,900 based on a number of violations, including an alleged failure to ensure towing operators completed annual drug screening, failure to carry required liability insurance, and for operating an incident management tow truck without possessing the required license. In the motion for rehearing, the respondent simply stated, family towing is requesting a rehearing on the case. As I have mentioned before, this is insufficient. There have been no allegations of legal or factual error on the part of the department, nor has there been any allegation that notice was not received. So our office would recommend denying this motion.
A motion for denial.
I'm going to make a motion to deny.
Second.
We have a motion and a second. All in favor signify by saying aye.
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 Those opposed? Motion carries 4-0. Thank you, sir.
Thank you.
Let's move on to the contested cases, F2, which is Jim Israel Martinez. Mr. Sharp. I believe we are, Mr. Martinez is here, represented. Mr. Sharp. See at your leisure.
Morning, Mr. Chairman, Commissioners. My name is Ken Sharp. I'm an enforcement prosecutor with the department. The respondent in this case is Jim Israel Martinez. The department proposes the revocation of his journeyman electrician license. In 2004, the department issued an electrician license to the respondent, and in 2016, he renewed that license. The renewal application asked the respondent whether he'd been convicted or placed on deferred adjudication for a criminal offense since his last license had been issued, which would have been his last renewal. He answered no, but that answer was not true. The evidence admitted at the hearing showed that, in 1994, he was convicted of unlawfully carrying a weapon. That charge arose, according to the indictment, after he had threatened a man with a firearm. In 2000, he was convicted of possession of marijuana. In 2004, he was convicted of assault, family violence, after he struck a woman with a beverage coaster. His sentence was suspended, but the court revoked the suspension and sentenced him to jail in 2006. In 2007, he was convicted of possession of marijuana again. Also in 2007, and this is while he was licensed, the respondent was convicted of assault, bodily injury. In that case, he had deliberately slammed a car door into a woman. And as with some of his other convictions, the court sentenced him to jail but suspended the sentence and placed him on community supervision. But in 2011, the court revoked the community supervision and sentenced the respondent to 365 days in the county jail. Now, the respondent renewed his journeyman electrician license on June 22nd of 2015, and that's important because 6 months later, in January of 2016, he was placed on deferred adjudication for 1 count of aggravated assault with a deadly weapon and 1 count of aggravated assault with a deadly weapon, family violence. And then, almost 6 months after that, he falsely reported on his renewal application that he had not been placed on deferred adjudication since his last renewal. The 2 charges for aggravated assault with a deadly weapon arose when the woman who had been living with the respondent apparently decided to move out and had brought some of her relatives to the home to help her get her belongings. The respondent testified at the hearing that he was asleep when he heard a suspicious noise. He said he confronted two men in his house with a shotgun until his girlfriend emerged from a different room. One of the men was the girlfriend's brother. He testified, the respondent testified, that when he saw his girlfriend and realized the circumstances, he put the shotgun away and left the house until they had finished moving her out. Now, the evidence provided by the police was starkly different and showed the respondent not only brandished a shotgun and pointed it at them, but threatened the girlfriend and her brother. Now, the girlfriend managed to get her companions outside, and she stayed inside while with the respondent and then called 911. In spite of the Commission's criminal conviction guidelines, the ALJ erroneously concluded that the two assaults in 2004 and 2007 were not directly related to the occupation of an electrician, and that you could not consider them as part of the basis for the revocation of the respondent's license. However, in a different part of the PFD, the ALJ characterized assaults as being generally related to the occupation of an electrician. She relied on the nature of most of the assaults as family-related violence to find that the respondent would not have an opportunity to commit acts of domestic violence at his workplace. And however, the Commission's guidelines don't make that distinction. Moreover, in a more recent incident, the respondent pointed his shotgun and threatened a man who was not a member of his family, even though the incident stemmed from a domestic relationship the respondent was in. The Department's concern is that a person who would commit violent acts against someone he cares for or one of their relatives would react to a confrontation with persons he did not care for in a similar manner, even if it didn't happen to be on the job, or hasn't happened to be on the job yet. Now, at the hearing, the respondent minimized his actions or denied that he had done anything wrong, but at other times acknowledged his criminal behavior and blamed it on substance abuse, which he said he used to cope with the adversities of life. The ALJ erroneously concluded the charge of unlawfully carrying a weapon back in 1994 could not be considered as part of the respondent's overall criminal history or other information that reflected on his trustworthiness and integrity. She did find that the respondent had falsified his application for renewal, but in spite of these findings and the evidence, which includes his failure to comply with the law on a number of occasions and court probation orders, and in spite of his falsification of the application, the respondent nevertheless, she said, had trustworthiness, integrity, and honesty. Now, the ALJ relied on the respondent's relatively recent completion of programs to presume that his rehabilitation from substance abuse and criminal activity was successful, and so did not recommend revocation of his license as proposed by the Department. However, in the light of the span of years over which the respondent has committed violent and other criminal acts, more time is needed to determine whether he truly has changed and will be fit to hold a license. The Department asks that you reject the PFD, amend it consistent with the Department's exceptions, and revoke the respondent's journeyman license. Thank you.
Thank you, sir. Let's move on to Jim Martinez and Jason, is it Danowski? Is that right? I remember from the first time. If you don't mind, state your name for the record.
I think about 1,000, actually. Jason, excuse me. Jason Danowski for Jim Martinez.
Okay. Thank you.
Jim Martinez.
Okay, go right ahead. Oh, I'm sorry. This is a SOA hearing, so again, we can only confine our comments to what was had at the SOA hearing. Can't bring anything from outside of that. If it wasn't presented at the hearing, we can't take it up here, okay? So confine your comments to that. Go right ahead.
Thank you for hearing us today. A state agency may change a finding of fact or conclusion of law made by an ALJ only if the agency determines the ALJ did not properly apply or interpret applicable law or agency rules. And the ALJ in this situation did properly apply and interpret applicable law and rules. The judge did explicitly acknowledge the difficulty posed by this case and the Chapter 53, Section 23, Subsection A, Subsection 1 factor most weighing against Mr. Martinez, which is the extent and nature of his criminal history. She stated on page 9 of the PFD, ordinarily, for a licensee with 2 recent felony deferred adjudications and 2 older crimes forming bases for a sanction, plus several older crimes as well, revocation would be an appropriate sanction. She then stated, "This is an unusual case, however, in that there are a number of compelling mitigating factors." She listed several factors that she considered to be the most significant factors weighing in favor of Mr. Martinez keeping his licensure. We think the two most important factors are the third and the fourth, which are discussed on page 10. She stated, third, Mr. Martinez testified persuasively that his behavior has been negatively influenced by drug and alcohol abuse, for which he has finally received successful intensive residential treatment. She further stated that Mr. Martinez testified that the placement with him by CPS of his young grandson gives him a potent incentive to remain drug-free and alcohol-free. And we would also like to bring your attention to the letter from the community supervision officer, Mr. Martinez, which is discussed just below that. He characterizes Mr. Martinez as having exhibited, quote, exceptional compliance, end quote, meeting all requirements and voluntarily going beyond them with regards to his community supervision and his rehabilitation. I'd also like to respond to Mr. Sharp's statement that Mr. Martinez denied that he did anything wrong. This was, as stated in the PFD itself, not characteristic of Mr. Martinez's testimony with regards to his criminal history. On page 7 of the PFD, quote, he stated that his 2004 and 2007 domestic violence offenses involved against his then wife, to whom he was terrible, quote, end quote. Further, he stated that he had been a terrible father, a lousy husband, and had done bad things to his loved ones. Mr. Martinez acknowledges the seriousness of his past criminal history, but brings to your attention the rehabilitation that he's undergone since his most recent conviction. Thank you.
Mr. Martinez, do you have anything to say?
Well, I understand why I'm here today. You know, I did live a life of crime, and it was terrible. I needed help. I didn't know what I was doing throughout the years. My life was screwed up. I tried so many times to break these chains, and I couldn't. It took rehab for me to realize how to take them off and keep them off. You know, I can't change the past, but I can definitely change the future. You know, CPS gave me a chance with my grandson. You know, my higher power gave me a chance. I'm asking y'all to give me a chance, you know. It's a new life for me, and I enjoy it. I have so much to lose now. Before, I just didn't care, you know. There was no hope. Thank you.
Any questions for either Mr. Danowski, Mr. Martinez, actually even Mr. Sharp? The PFD necessitates to suspend Mr. Martinez's license for a period of 5 years. There should be a probated suspension, is that correct?
Yes. That's what the PFD recommended. But we don't have any way to monitor those things. I mean, it might as well just be an unfettered license.
Well, except if we probate it, if we're giving him a chance to see if he recurs, then it's an automatic revocation, correct?
He still has due process where he gets to go through the hearing process and so forth. So, and we probably wouldn't find out anything about that until the next renewal. So we would essentially be in the same position we are in if there had been an unrestricted license.
Commissioners, questions, comments, or a motion?
I have a question, and maybe this wasn't probably brought up during the hearing, and if I'm out of line, counsel, let me know. Do we have any evidence that Mr. Martinez has gone through any type of rehab?
I'll defer to Mr. Danowski on that.
Would you like to speak to
There was evidence at the hearing, but...
It was presented at the hearing that he did
Yes,
go through
there was
rehabilitation.
a substantial amount of evidence with regards to his rehab. Mr. Martinez went through a residential inpatient, am I using the correct term there?
Yes, sir.
Treatment program for 3 months.
Yes, sir. It was 3 months long in Henderson unit.
And then
When you were
following...
incarcerated?
Yes, they sent me from there to Henderson Unit. Once I completed that, then they set me free.
Following that, you were in Recovery Works?
Yes, I'm still doing all kind of programs right now. One of them was 6 months long, and even after I graduated, I still continue to go to that class because I was benefiting from it, and I had time on my hands, so I'm still continuing to go to it freely.
With regards to what he was just speaking of, returning to that program, this is discussed on page 8 of the PFD, which quotes a letter of recommendation by Mr. Martinez's community supervision officer, which stated that the first phase was completed on June 21st, 2016, relapse prevention group, followed by Recovery Works, which he completed on 12/14/16.
I have
However,
another question, maybe for the council or somebody on staff. Just a question, if we were to grant the PFD, I understand the applicant has a journeyman electrician license. Would that stop them from getting a master's license or any other license above the journeyman license?
If there's a revocation, number one, he would not be able to apply for a journeyman license for a year.
Okay.
And the experience requirements need to be a master, would have to be evaluated, but also this would factor into an application for that as well.
I was just concerned about the 5-year period.
You're talking about suspension, not revocation.
Suspension.
Okay.
Suspension, no.
No.
He would still be earning the hours, he'd still have a license.
But
That
he
would not-
he could potentially, within the 5 years, get a master's electrician
Absolutely.
license.
Yeah, if everything's met, time, fees, experience, pass the examination, this would not bar him.
Okay.
Any other questions or comments or a motion? Thank you. You can have a seat.
thank you.
Commissioners, discussion or a motion would be in order?
I think my record for motions is kind of much higher than the other commissioners, so I'm going to kind of defer back to the other two commissioners. I'm kind of winning on the making the
That's an
motions.
easy way out.
Yeah.
Cutting to you, Helen.
And have there been any issue, I guess we were through a question, but I just wanted to know if there have been any issues since, you know, the filing and the hearing of this.
Well, we
I
would
don't-
know what
yeah.
happened after the
Yeah.
hearing. The
Yeah.
evidence only went up to that
So
point.
nothing's been, okay, got it.
That's,
recorded.
yeah, nothing else would be in the record, Commissioner.
I'm going to make a motion. Feel like the administrative law judge has done their due diligence in this case and weighed all the conclusions of the law. And for that very reason, I believe that we should go ahead and adopt the PFD as presented.
Your
So-
motion to adopt the PFD as presented?
That would be my motion.
Second would be in order. Motion dies for lack of a second. Commissioners, a motion for the other side?
And again, clarify for me, I guess, for adopting the PFD, and even though that one's died, what can take place during the 5-year period for the suspension?
Well, even though that's there, I mean, we could still change it, but essentially, he'll be able to continue working. And depending on how you structure your motion, if it's adopted, he would have to comply with all the rules and statutes of.
Already is, but are we able to add anything into that, like continuation of the type of workshops or sessions that he's in now, or
Documented
Any
proof
type of- right.
of his, I guess that could be a part of the motion for him to
Did-
submit.
Haven't we
Mr.
done
Chair.
that in the past, or we put it on, the burden on the individual seeking the license, that we require them to provide with the notice that they are continuing to attend classes, or?
Yeah, this is Brad Bowman, General Counsel. I think that the appropriate sanction here is within the authority of the commission to determine, and under Chapter 51, you're allowed to impose reasonable conditions of probation if you probate a suspension. And so there could be some terms like that, in addition to what the ALJ recommends, that you could impose if you choose to do that. We just need to work out the details of that to have on the record.
Okay. So Commissioner Yarko would, something of that nature?
Sure.
Okay. I don't know what that would look like, but, so I would make a motion to, well, adopt the PFD, but I want to add onto that, the monitoring piece where he's reporting, continuing with the workshops and the classes that he's doing. I'm not
And
sure how
report
would
that
be.
back to the agency.
And report that back to the agency, and I don't know if it's once a quarter, I don't know how the classes are being taken now. If it's once a month, once a quarter, what's something that's reasonable?
Can I advise, can we advise Commissioner how often he's taking classes and what they cost?
Sure, come on up.
That might be helpful.
Real quickly, just tell us how often you're taking these
I
classes.
take a class once a week.
How often do you have to do that, and for how long?
I'll be doing classes for another year, exactly, once a
Okay.
week.
So I guess your motion would be that he submit documented proof on a quarterly basis that he's taking these classes and not missed?
I'm okay with quarterly.
So that's a motion. Did we get a second? I don't think we did.
Not yet. She just made the motion.
Right, okay. So we have a motion on the floor, which is basically to modify the PFD and have the respondent submit quarterly documented proof of the classes that he's currently taking through. Is it Recovery Works, is that correct?
Yes, sir, it's various classes, but they're all consistent.
And Mr. Chairman, that would be in addition to the requirements that the ALJ has
That's correct.
suggested in the PFD.
That's the motion that's on the floor. Motion's on the floor. Motion
What's
died.
your motion with one addition to it?
Commissioner Yoko, feel free to make the second.
No.
Well, motion
You don't
died
have
for
to
lack
ask
of
me
a
to do
second.
that, do you?
Motion dies for lack of a second. At this point in time, I would probably say that we probably have to push this off to our next meeting for failure to have a consensus amongst our commissioners.
Okay, can I try?
Sure.
Okay. Move to adopt the PFD and to add in it a requirement of notice that he is completing the requirements of the courses weekly, and the reporting can be quarterly, and that it is under his obligation to notify the agency if he is subsequently arrested.
So we have a motion on the floor.
Because I like Commissioner Yurko, I'm going to go ahead and second it, but I will make a statement that I'm not a huge fan of the reporting part. That puts a little extra burden on the agency. But for this case, I'm going to waver a little bit and say yes, go ahead and accept my second.
So we have a motion and a second to modify the PFD. The respondent would be responsible for submitting documented proof on a quarterly basis of his weekly meetings, and to also notify the agency in the event of another arrest. Is that correct? Correct. So, all in favor signify by saying aye.
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 Those opposed, no. Motion carries 3-1. At this point in time, we're going to go ahead and take a short break. It is 10:28. This meeting will come back in order. Staff, just kind of FYI, contested cases 1, which is Falcon Towing Recovery, 3, Gerald Glenn Coleman, 4, Frederick Clark, will be carried over to the next meeting for failure to have a quorum. Executive session, we will not have one. Approval of minutes will carry over to the next meeting.
Yes, sir.
Mr. Chairman, that would be the July 28th meeting, am I
It'll be,
correct?
No, it's going to be June 16. You will hope that we have a quorum then.
My apologies, June 16th.
June 16th, yes.
Mr. Chairman, we also need to, I believe we need to carry over the votes or approving the absences for today's meeting.
If we want to.
Yes, sir, if we want, to. If you're so inclined.
We're so inclined. That'll be carried over to the next meeting. Also, item I, which is approval of advisory board members, will be carried over to the next meeting. We received our great advisory board report from the wonderful Mary Winston. Let's now move on to public comment. We do have one here, Lori. Is that Firmgen? Firmgen? Okay, come on up.
Good afternoon, Chairman,
Since you're an
Commissioners.
employee, you have actually 2 minutes.
I have 2 minutes, okay.
Go right ahead.
My name is Lori Fremgen. I'm a midwife. I'm a licensed midwife and a certified professional midwife. And I've served on the Midwifery Board for the last 10 years and now the Midwifery Advisory Board here. I watched the commission meeting on April 5th when you were hearing a case involving a licensed midwife. And I noticed that there was a little bit of a scramble at the end of the hearing to find appropriate continuing education for her, and and decide how she was going to get her retraining. And so I just wanted to put a little sheet together as a guidance to help, just in case you have those questions come up again. These things are available in the midwifery community, training as well as teaching opportunities. One of the things I'd like to point out is our Association of Texas Midwives, which is our state organization, offers training, continuing education for midwives as well as for new students. And they also have guidelines regarding who can actually be a teacher. And so those guidelines might be something to consider when you have your next case. The other thing I wanted to point out is that previous case involved emergency transfer information or an issue. There is a class called the Birth Emergency Skills Training class. It's a 2-day class. It's worth 16 continuing education hours. It's a great class. There's a couple of them like that, and they travel across the country, so that might be something to consider as well. And then finally, the Midwifery Education Accreditation Council, which is our national accrediting council as far as education goes, they also offer continuing education. So you know that if you're choosing these courses, you're getting top-notch training and recommending something really, really fine. The final thing I want to mention is that all midwives are required to do peer review by our national accreditation body. And so that might be something to work into your recommendations as well. So this is available if you need it in electronic format or in paper. So that's it.
Yeah, if you don't mind, send that to Brian so he can have it and he can distribute it
Okay,
out to us.
yeah,
Appreciate
I just
it.
did. Okay, thank you very much.
Thank you.
I do have a question for council on this, Mr. Chairman, if that's okay. From a commission standpoint, are we allowed to pick and choose what agency someone takes CEUs through as part of a motion, or?
I don't think you'd want to get in that habit, but I think what Ms. Fremgen was pointing out was that if the commission was inclined to require continuing education, they now have comfort that there are several providers in certification programs that education will be received.
We don't stand a liability issue of trying to send somebody to a particular class or something like that, right?
We've never had recommendations that would favor one provider over another. So I think in just, again, just reiterating where she was coming from, which is there's plenty of education out there and there are plenty of qualified providers. And you could say something certified midwife programs, nationally recognized midwife programs, and you wouldn't be pushing out.
That's you. Thank you very much for this information. We appreciate it.
It's really good.
Commissioners, you have also, or should have, Friday, June 16th as a scheduled commission meeting date, Friday, July 14th, and Friday, August 18th. Those should be scheduled meeting dates.
Could you repeat those again, sir?
Sure. June 16, July 14, August 18.
So we had a, okay. And the workshop is?
You're right.
The
The
28th and
retreat
29th.
is scheduled for the 28th and 29th here in Austin. You'll be receiving further detail on that as we begin to start solidifying and trying to get out of this session. We'll get some further information on it. But
Just asking on the 28th, is that mostly an afternoon session?
primarily, it's going to be afternoon, and then we'll go into Saturday morning.
Okay.
Correct.
And this is going to give us, the retreat is basically going to give us the opportunity to be able to do some visioning, some planning, future planning where we're going to be at, especially as we have some of these new programs that come to us and how we're going to handle them along with the other health-related components that are currently with us.
Okay. I'm not really dense, but I just want to ask another question. On that Friday, the 28th, we don't have a formal meeting
That's correct.
to hear any cases or
No,
anything like that?
no.
That's correct.
Now, I'm glad you mentioned that. And so, this retreat that we have will definitely be straight away from our traditional meetings that we have where we consider cases, where we consider motions for rehearing,
Okay.
hear staff reports, rules, those type of things. Totally separate. It's just going to be more from a planning perspective for the future of TDLR, where we're at, what we can expect, kind of some just ability for us to be able to kind of gather our wits about us as we begin to start having more programs to us and what they'll look like.
Right. And so, for the audience that's listening, the workshop is basically just for the commission and the staff? not for
It'll
public.
But it'll be a
It'll be
public
a public
meeting.
meeting.
Correct.
But it'll be primary. If they want to come in and listen to us
Yeah.
ramble on, as you're doing right now, then we can definitely have them do that.
Thank you.
That's brutal.
You get to say anything with that gavel. It's awesome. You bring one of those home.
It's a big stick. It's my big stick. Well, that being the case, and because of the fact that we do not have a quorum,
I would like to make a couple of comments before you gavel to close, if that's where you're going.
I was about to gavel and close.
So, doing a follow-up from, if I may, because I can't recall which all staff updates were done, with the exception of the executive directors on the legislative session component. I was at the architectural barriers meeting, whatever day that was, and there was comments about, was it George? In regards to getting a hold of some of the architectural, universities as well as community colleges. So the dean of architecture at the University of Houston will be in contact by before the fall session will kick in, and they have my card and information that comes here. I'll give you his name. It's not on the top of my head right now. And I spoke with Dr. Gonzalez, who's the chief of staff for the chancellor of Houston Community College. And I do have a card, and they're open in order for you guys to speak. So does that give you my check marks, Mary?
Thank you so much, Commissioner Collier. I appreciate it. This is very helpful for our architectural barriers program, and she so graciously attended, and a report was given by compliance that they have been educating, because our RASs are older than younger, and it's a profession that younger students aren't aware of, so we want to branch out, and George's team has been providing training and interactive workshops and making the younger crowd aware of this profession.
I want to make note that the comments made by Commissioner Collier and Mary is in reference to the advisory board reports that we've already received.
Thank you so
So-
much, Chairman.
So we're not out of sync. So, there being nothing else coming before the commission?
Brad breathed. He was holding his breath, and when you said that, he exhaled.
He was starting to turn a little blue, is the reason I said that, so that he could breathe a little easier. So, there being no other, nothing else coming before the commission, we're now adjourned.